and I'd like to welcome you to our real estate home buying and selling seminar. I'd like to start by introducing our Commissioner of the Department of Consumer Protection, Brian Gaffarelli.
All right, thank you, Jay, and thank you all for being here in person and online. I'm very excited about the home buying and selling seminar. That it's the first one that team is putting on today, so there's a lot of useful information that we think is very helpful in your endeavors. So I'm going to let everyone get right to it, but wanted to welcome you all and thank you for this, and look forward to the Q&A and the responses from this. More to come and a lot of good stuff. So thanks, Jay, and everyone.
All right, so we have with us today a number of members of our team. We have Joe Conklin and Mimi Sahara Long are our real estate examiners, longtime real estate professionals, bringing a wealth of experience. We also have Kylie with us, who's interning with us this semester. We have members of our legal team who will be supporting us as well. Introduce themselves.
Annalisa Villard, attorney with the department.
Morning, everybody. My name is Paul Grabowski. I'm a legal program director of Consumer Protection. So Annalisa and I handle a lot of the enforcement issues with state agencies.
And as I said, my name is Jay Cohen. I'm the Director of Operations with Consumer Protection and oversee the real estate unit. So today's
Question. Do you mind putting it in presentation mode so that we can see all the slides?
you know, the slides. Well, the slide we're talking about should be on the screen.
It's the button at the bottom. It looks like a screen to the right. Go to the right. One more to the right.
Behind that. There you
Yeah, right there. Thank you.
go. So today's presentation is geared towards the public, the buying and selling public. Not necessarily towards licensees, but we know we have a number of licensees with us today. And we're glad you're here as well. So thank you. So very first thing that we do want to let buyers and sellers know that probably the most important thing you can do is get yourself a licensed real estate professional to work with. They are, they go through a lot of training and a lot of education to get that license, to make sure that they know all the laws, everything in the market will help you get through this process the best way possible. And there are, parties involved, at least in every home sale, obviously the seller and the buyer. So each party should have their own representation, and we'll get into the details of what that looks like. But now, is it required? No, and we can talk about that as well. But again, our best recommendation to you is to work with a licensed professional. Now, there are two types of professionals that you want to know about. So typically, you're going to work with a salesperson. They work face-to-face, with the consumers to sell a house, to buy a house. But every salesperson works for a broker. The broker is the actual entity that is buying or selling that, doing the work of buying and selling the house with. And you can work directly with a broker as well. Salespeople are individuals. They're human. They can have a first and last name. Brokers could be a person or it could be a business entity. So you want to make sure you know what you're looking at. And no matter who you're working with, a salesperson or working with a broker should be familiar with who that brokerage is. Because again, the salesperson is a representative of that broker. The broker that you're actually working with, and that's where the sales go through. So all of the advertising you see, whether it's online, sign in front of a house, ad in a newspaper, you should see the broker's name, phone number, email, so that you can reach them along with the salesperson.
Going to get more depth into both these
Are we ready to move forward?
Sure. And just quickly, let me mention, one other thing you may see advertised that is relatively new are teams. And teams are just groups of salespeople or brokers that are working together. So you may see a team name advertised. But the goal of any of this is for you to be able to know who you're working with and be able to contact us, find information about the licensed professionals that you're working with. And ideally through our website, and we'll get to that in just a moment, how you can actually look them up. But Bill, sure,
Do
please
you want
jump
me to
in.
go on with the broker, salespeople and teams, and then we'll have to be licensed?
Sure.
Okay, so, you know, in real estate, we have brokers and we have salespersons. They're often referred to as agents. I'm going to use all those three terms back and forth. They're professionals who help clients buy, sell, or lease properties. They have different roles, responsibilities, and level of licensing and education. Salesperson, a real estate agent, is the first point of contact for a client. They work with buyers and sellers to help them navigate the process of purchasing, selling, or renting real estate. The key characteristics of a salesperson is a license that's required. Salespeople must complete a specific number of course hours and pass an exam to obtain a salesperson's license. A salesperson works for a broker. They cannot work independently. It must be affiliated with the licensed broker who oversees all of their activities. The role of a salesperson is to help clients find properties, they show homes, negotiate offers, handle paperwork. They are the day-to-day point of contact in real estate transaction. Just touch on commission. Salespersons are typically paid by commission. It's a percentage of a transaction shared with the broker.
So if you could just speak just a little more loudly for the microphones. I think so, just a little more loudly.
Okay, so some of the responsibilities of a salesperson is to assist buyers and sellers in finding properties, show properties to potential buyers, write and submit offers and counteroffer, coordinate meetings, inspections, and open houses, advise clients during the transaction process. Now, for the real estate broker, a broker is a real estate professional with advanced education and training beyond that of a salesperson. Brokers are licensed to operate independently and can own and manage an office on their own. Key characteristics of a broker is higher licensing requirements. Brokers must have additional education, experience, often several years. As a salesperson in Connecticut, you have to be a salesperson actively engaged in business 3 years before you can even apply for a broker's license. They also must pass a test before they can become. Brokers can work independently, run their own firms, whereas salespeople, like I said before, work underneath the broker. Brokers can manage and supervise other agents and salespeople, ensuring that they follow legal and ethical standards. Brokers oversee the entire transaction, ensure compliance and regulation, handle contracts, manage the business side of the real estate operation. Brokers also supervise and train their agents or salespeople, ensure legal compliance with transaction, manage the business operations of the brokerage, negotiate more complex, higher level transactions, handle contracts, payments, documentation at a higher level. Now, I know Jason mentioned teams. Teams are generally a group of 2 or more salespeople or brokers that come together, advertise under one. They advertise their real estate business to provide clients a comprehensive range of service. Instead of having a single agent working solo, the real estate team splits their responsibilities. And, someone may be better at one thing than another, so they're going to split it up. So a typical real estate team would include a team leader. It's usually the most experienced team member, often the top agent or broker. They oversee the operations, handle complex transactions, and help the team direction. Could be somebody they refer to as a buyer's agent. They specialize focusing solely on helping buyers find properties, make offers, and navigate the buying process. And they could have a team member that's primarily a listing agent who would specifically work with sellers, helping them market their property. There could be administrative staff. You could have a licensed salesperson that's an administrative staff on a team. And they just assist paperwork, scheduling, client communications. Most have a transaction coordinator. This would be somebody that would handle the paperwork, make sure the deadlines are met. Be a marketing specialist. People are focused on promoting the listings through ads, social media, and other marketing channels. Client coordinator. Handle ongoing communication with the client to ensure their needs are met, make sure everything stays on track throughout the transaction. Basically, those are our three types. We have salespeople, brokers, and teams. Teams are registered. They actually come together to register, be licensed.
So speaking of e-license, we're actually going to jump on now and show you how to use our online system. So you can look up licensed professional to make sure that they are licensed with us and that their license is active. If it's a real estate salesperson, you can see who their broker is. So we're going to turn this over to Kylie here.
So to verify that your salesperson or broker is licensed under the state of Connecticut, you can go to www.ct.gov/DCP. That is our website. I'm going to take you here. Okay, so on our website, I'm going to take. Sure, share. It's up there.
Okay.
Everyone can see. So you're going to go to the verify a license tab. And down, once you scroll down on this page, we also have a video and step-by-step instructions that you can refer to if you don't remember what I am telling you on this presentation. But what you want to go to is right here, and this will take you to our e-license platform where you can look up a broker or a salesperson's name. So first I'm going to look up Jason Cohen as an example. So this is going to be your salesperson. So if you have their first and last name, you're going to enter it in those boxes, and then you can just hit submit. And in order to verify that you're clicking on the right number, as you can see, multiple licenses come up. A salesperson will have RES at the beginning of their license number.
Back up a
Back
second.
it up. All right, so they didn't see any of that.
No, but you can
Okay.
actually go back to our website.
Yeah, I'll start from the website. So let me just start over for you guys. Sorry about that. So here we are on the Department of Consumer Protection website under the Verify License tab. We have the video instruction right here and the step-by-step instruction right here also. And then we're going to go to the look up and verify a license for registration. So on here, I'm going to type in Jason Cohen. This is going to be your salesperson. And then submit. Like I said before, RES will confirm that your person is a salesperson. And once I go into this tab right here with RES at the beginning, this will show that Jason Cohen is an active real estate salesperson. So this will ensure that you're working with him and able to complete a legal transaction. It'll also show you the effective date and the expiration date of their license, as well as when it's issued. And you're also going to see their broker name. So this is Jay's Test Company. I'm going to use this as an example to search up a broker name in a different tab. So brokers will have the REB at the beginning of their license number also. start from the beginning. So now I'm going to search up a broker under the business name. So I'm going to type in Jay's Test Company.
One thing to note when you're entering names, either a business name or a salesperson's name, you have to make sure you get the beginning of the name right, but not necessarily the end. So if you wanted to look up Jason Cohen, you could put up JASCOH. So if you're not sure of the entire spelling of a name, you can just have the beginning. Same thing with a business. You can put Jay's Test, you don't have to put Jay's Test Company. That way, if there's an LLC or an Inc. or something like that, you'll find it. But if you put Inc. and it's really LLC, you're not going to find it. So it's one of those situations where less is more, but the beginning of the name does have to match.
So as I was saying before, our REB is your broker license number or beginning of your license. So we're gonna have similar information on this screen, is their credential, their potential type, and that their license is active. So they're legal to be practicing real estate in the state of Connecticut, as well as the expiration and issuance, as well as their address. So that is how you find a broker or a salesperson on our license platform. There is just to go back to give a quick reminder, business name for your broker and the first and last name for salespeople.
Wonderful. Thank you so much, Kylie. We will return to our presentation here. Okay, so required documentation. There's lots of paperwork that's involved in buying or selling a house. As you would imagine, and as with everything involved in the process, it's for everyone's safety to make sure that everyone's on the same page. You have all the details, nothing's left out or missed. And one of the first things you're going to do is sign a representation agreement with the licensed professional. It's just saying, all right, we're going to work together. And this is going to outline how you're going to work together. As with most things involved in this process, there are standard documents that a lot of professionals in the industry use, but know that you can negotiate everything. So you want to make sure that you're working with someone you're comfortable with and that you're on the same page. Some of the key details that are going to be in this representation agreement that you want to understand and come to an agreement are commitment length. So how long are you committing to work with this professional? It can be as specific as just today for this one house we're looking at. It can be for a year or longer or anywhere in between. But again, and there's no right or wrong. It's just a matter of making sure you're on the same page. Now, there's also dual agency. So as we said, the buyer and the seller each want to have representation, but in many instances, both of those people can work for the same brokerage. It is legal, it is okay. And in some cases, it can be the same person. One salesperson can represent both the seller and the buyer. But that's something you want to consider. Can one person necessarily represent both? In many cases, yes. Other cases, you might not be comfortable with that. So you just want to know, is one person representing both? Or you could each have your own person who work for the same brokerage. So again, you're having your own representation, but ultimately, since they work for the same brokerage, it is that same brokerage representing both of you. And that's called designated agents. So dual is when brokerage is representing both people. Designated is when it's the same brokerage, but two different salespeople from that broker. And of course, you could have salespeople that work for entirely different brokerage, which is usually the case. There are a variety, but again, when you're doing that representation agreement, you want to know, and if there is a dual or designated agency arrangement, there's a separate acknowledgement that you should be presented with and signing, just so that the brokerage is letting you know whether it's dual, or designated agency. Jill, if you have additional
When
comments.
you're listing a property, if you're a seller and you're gonna list your property, usually at the listing presentation, when you're signing that listing agreement, the agent is gonna talk about dual agency. It should be brought up right then. When the property's being listed, because then you're not handling something at the last minute when it pops up. They'll ask you if you want to allow their brokerage to represent a buyer and a seller. Have the right to say yes or no at that point. If you decide to go through, I mean, that's part of the listing agreement. You have them represent both, or you could say, I wanted designated agents. You could have two agents within the same company working on your behalf. If you're a dual agent, I don't know if you want to get in full on dual agent right now, but there's potential conflicts. Because dual agent is to remain neutral. They're not for one party or the other, since they owe no loyalty either. For example, a seller wants a high price, a buyer wants a low price. It may be difficult for that agent to fully represent either party. When you're a dual agent, kind of on your own, they're going to facilitate all the paperwork. You're going to make decisions. They're not going to, if you ask them to give you comparable sales, they can print them up, but they're not going to sit down and go house for house with you what they are. So you really have limited representation. A first-time home buyers probably shouldn't get a dual agent. Because dual agent, there's specific times when you shouldn't. Let's say Amy's an agent, she's selling me a house, but it's her mother's house. Do I want to be the buyer when she's representing her mother? Probably not. So every situation's different. Both parties have to consent. Sellers and the buyers must consent to dual agency in writing. So if they don't, it won't happen.
This key is just think about who you're working with and who they owe a duty to. If someone owes a duty to anyone other than you, it might not be the best arrangement for you.
In a traditional agency is one agent represents the seller, one agent represents the buyer. That's the traditional way. But in Connecticut, a dual agency is allowed.
So, as Jill mentioned, there is the listing agreement. So
Listing agreement is actually a formal contract between the property owner or owners, and the real estate brokerage. The broker owns the listing. Might say, oh, I listed with Sally salesperson. Well, the broker is actually the owner of the listing. So if Sally leaves that company, that listing stays with ABC. Well, listing does is it grants the agent the authority to market and sell the property. The agreement outlines the terms, the agent's service, being their responsibility, commission to the seller for services rendered, contract duration. So the commission agree. Commission is the rate that the agency charges to sell a property. That is not a fixed rate. That is a negotiable rate. So it's something that the seller is willing to pay and the agents accept. Could be limited service. Some people say, I just want it on the MLS. I'm going to do everything else myself. Lesser fee there. Totally negotiable. I'm not going to get into all the different ways you can do that, but it's you can look online and find it. There's a duration of the listing. How long is it going to be? Is the listing going to be for a month, 3 months, 6 months, a year? That's negotiable. Make sure you're paying attention to that. Listing price. Listing price is negotiable. It's the agent's duty as representing the seller to a market analysis to come in with hard evidence why a property should be listed as XYZ. just pulling something out of the air. They'll have comparable sales for properties in the. We already talked about dual agency. A listing agreement is a vital document in the real estate process, must be in writing and signed by all owners. Sets the stage for the sale of the property, establishes the relationship between the seller and the agent, including important details. Contract helps to ensure that the seller and agent are aligned, are protected during the transaction.
So all this said, it is not required that you work with a salesperson or a broker. It is legal to be unrepresented, to sell your house or to buy a house. Certainly if you have expertise or knowledge, that there are options. But often if you are one of the parties and the other party does have representation, you're going to want to, they're probably going to ask you to sign an acknowledgement to say, hey, you're not represented.
There is a form for that, an unrepresented buyer. There is an unrepresented buyer form. It refers to a situation where the property buyer is not working with a real estate agent or a broker to help guide them through the process. This means that the buyer is handling everything independently without professional representation, provide advice, negotiations on their behalf, assist the legal, contractual aspects of the transaction. Lack of guidance without an agent buyer is the responsibility for conducting their research. So the buyer would have to conduct their own research, understand the market, ensure that the property meets their needs. They also handle negotiations of their own paperwork. But typically, a seller's representative would complete any forms that a buyer would need, even though the buyer was unrepresented. There are potential risks for being unrepresented. Buyers might miss out on a market insight, fail to properly vet the property, overlooking details of the property. There could be unrepresented buyers and there could be unrepresented sellers. So we've all heard of FSBOs, for sale by owner. A for sale by owner is a seller marketing their own property. Many times, a real estate agent will approach a seller, sale by owner, and say, hey, I have a buyer for your house. And I come in and show it. So now the seller's unrepresented, but the buyer is. So that's another way of, it goes on both, it's on both sides.
So one of another key piece of documentation that you're going to want to have as either a seller or a buyer is the disclosure report. And we're going to have Mimi tell us a little bit about the disclosure report.
So I actually,
Bring this up on the screen here for you.
I actually get a lot of complaints in regards to the residential property condition report. So I'm gonna touch on it. It's really important for the seller to fill out this disclosure. Because what I'm seeing with the complaint is that either the seller wasn't honest, property disclosures, or it wasn't given to them. And it can end up in a civil court. So I'm going to touch on a few important aspects of it. So it's required to disclose certain information about the properties, such as known defects, past damage, or environmental issues. In Connecticut, it's called a residential property condition report. This report must be given to any potential buyer prior to making an offer. There are a few exceptions where the disclosure is not required. One, any transfer from one or more co-owners solely to one or more of the co-owners. Two, transfers made by the spouse, mother, father, brother, sister, child, grandparents, or grandchild of the transfer. Three, transfer of newly constructed residential real property for which an implied warranty is provided under chapter 827. Or transfers made by executors, administrators, trustees, or conservators. 5, transfers by the federal government, any political subdivision thereof, or any corporation, institution, or quasi-governmental agency chartered by the federal government. 6, transfers by the state of Connecticut. 7, any transfer of property acquired by a judgment of strict foreclosure or foreclosure by sale, or any deed in lieu of a foreclosure. And if the seller fails to provide the residential condition report, the buyer is entitled to a $500 credit at closing. And the buyer must notify the closing attorney if you did not receive this document. And-
But I'd just like to caution, you're much better off getting the report than the $500. So don't forego the report, hoping that you're gonna get $500 later. Because the report is gonna tell you, should be telling you everything that you need to know or want to know about this house. But that said, take it with a grain of salt, because this is being completed by the seller who wants to sell their house. And so the seller completes it, gives it to their listing agent if they're working with someone, who provides it to your representative if you're working with someone, who then provides it to you. So it's going through a number of hands, it's getting to you, and you and the buyer's representative want to verify everything that's on there. Just because it's written on there, don't take it for granted. There may be things that are either incorrect or missing. For instance, if work was done on the house and no permit was pulled, and that's not on there, you want to be doing your own research, go to the town hall, check with the building department. And, if you notice, you ask them if they're aware of any open permits, but also if you've seen or know that work was done on the house, you can see if actual permits were pulled for that specific work. Because once you buy the house, any work that was done without a permit is now on you as the new owner. So you want to take everything you've got and look for more information. Sorry if I'm stepping on it.
No, that's okay. And I just want to add that we have this on our website for any sellers, to just print out and fill it out, the residential property condition report. So it's right on our, DCP website for everybody to print out, well, for the sellers to print out and, say, especially for FISBO property owners.
Next question. On your website are all the forms there?
Not all of them. We definitely have the residential property disclosure report.
The forms that we're covering here are on our website.
Yeah.
What's not on our website are contracts for listing and sales.
Yeah, every licensed professional has their own version of the contracts that they use.
Also, the property condition report cannot be filled out by the real estate professional
Yeah.
at all. It's supposed to be hands off.
And for that reason, they're not responsible for what's on it. They get it from the seller and pass it on to the buyer. So if something is left off, it's not the responsibility of the licensed professional, unless there's a reason that they did know, or should have known something. But in general, it's not the real estate professional's responsibility to verify the accuracy of what's on that disclosure report. So you as the buyer got to do your due diligence with your professional, and that's what they're there to help you with.
The buyer, when they read that report, they can say, oh, what about this? I'm not sure about this. Go to the town hall, go to the building department, pull the file on that address. They'll bring out the file, they'll let you look at everything. You'll be able to see, some towns have it online now, but it doesn't hurt to take a trip. Or ask your agent, if you're paying an agent that represents you as a buyer, ask your agent to go to the town hall, go with you and look at it. There's really important stuff there. You'll see if a house was ever condemned. Did it have a fire? A fire could affect the insurance. Are there open permits? Is there a brand new beautiful deck but no permit for it?
And one thing that's not specifically on the condition report at this time is solar, issues with solar. If you see that there are solar panels in the house, you want to do a lot of investigation to understand what the arrangement is, because there are multiple arrangements that the seller could have. They could have bought those panels outright and they're part of the house and use buyer own them, which is probably the best, situation for you as a buyer. Or they could have a lease where they owe money and either they're going to maintain the lease or you have to take over the lease. And then there are what's called power purchase arrangements where no one house owns it. They're just basically letting the company put the panels on there and they're selling you the power. So there's probably even additional varieties, but there's a lot of different scenarios. And it doesn't mean you can or shouldn't buy a house with solar on it. Just know what you're getting into beforehand.
The thing about solar is, the solar companies, when somebody's assuming taking over an existing lease, buying a house with solar, the new buyer's gonna assume it. The solar company doesn't want to talk to that buyer until the closing has already happened, which is kind of a scary situation because the solar company wants to qualify the buyer, see if they can afford to take over that payment. And what happens if they can't? They come out and take them off the roof. Now you got all these plug holes all over your roof. I mean, it happens.
Yeah.
So when you see solar, you really have to take a break. I think solar should be handled like a home inspection. You should be looking at that in the first 2 weeks. So you have a way out if there's something that doesn't jive with you. Fire.
Again, it's not bad. It could be great that there's solar. Just understand what you're getting involved with. Any
So
other
we,
comments about the condition report?
people tend to, homeowners don't really know what to put on there. I mean, I've been a broker for many years and they've always asked me, what should I say? I think, the best of your ability to complete it. I can't really help you. But, you can always come back, making an offer and ask questions. List of questions with your offer. You can, during your inspection period, have questions that you want more details. Or if something doesn't look right, get a professional, HVAC guy or roof guy or whatever. And it may have been, yes,
Right.
going on to purchase agreements. Yeah. Right, we have purchase agreement.
Yes, purchase
Yeah,
agreement.
so purchase agreements, it's a sales contract or a real estate purchase agreement. Is a legally binding contract between buyers and seller, and the buyer and the seller of the property. This agreement outlines the terms and conditions of the sale, including the price, the closing date, any contingencies. And it's one of the most important documents in the transaction. This is where the buyer's agent draws up the contract. In some parts of our state, they do a binder and then an attorney draws up the contract. But the buyer's agent puts all the details in there that the buyer wants. So, you're going to have the names of the buyer and the seller. You're going to have their address, their legal names, not their nicknames. You're going to have a purchase price. You're going to have earnest money. Earnest money is the initial down payment. You're buying a house, you're sitting with your agent, you're writing the check for deposit. That deposit is a good faith gesture towards your offer. It says, I'm serious. I'm gonna proceed with the sale.
And that deposit gets held in escrow. So it's in basically a third party place where it's not held by the seller or the buyer. It's held in an account arranged by the seller's broker.
Usually with the listing broker holds the escrow. However, some people may want to have it held with an attorney. Some agencies don't. They let it go with an attorney. If you're building a new construction and you have, let's say, $75,000 deposit, they don't want it held with, they want it held with an attorney, and they may even want it in an interest-bearing account because it could be tied up for a year. So there's all different types of deposits, but if you're never held by the seller, they should not be held by the seller. There's a little box on contracts that say deposit transfers at time of closing or a transaction closing or not before. You never want to keep that up before. So then we get into contingencies. Contracts have contingencies. Buying a house, you have a contingency where, hey, I need to get a mortgage. I'm going to qualify. You might have a month, 45 days to get a mortgage. That's called the financing contingency. You have an inspection contingency. These are all options. You don't need to have them. But if you need them, you should have them. Because you're going to have to close. You won't have any way to not close on the property. If you, for some reason, your credit came up and there was an old car loan or something, and they say, okay, you don't qualify. You want that deposit back. You don't have contingencies in place, then you're not going to get your
And
deposit back.
the seller can have a contingency too. They could have what's called a Hubbard clause where they could say, we're making this deal, but only if I can find another house that I'm moving to.
Yeah.
Um,
And those should have dates on them. Every contingency has to have a date. Even if it's like Jason said, I'm selling my house, but I can't buy unless I sell. So I'm going to sell it, but you're going to give me 2 weeks to find something. And it's going to say in there a date this expires on. And if Jason doesn't find something, then he's going to come back to me and say, hey, I didn't find anything. I know you really like my house. Will you give me another 2 weeks? And a lot of times the buyer has the right to walk out at any time. Just you're giving them time to find something, especially in a market like this.
And
Not
if
a
you,
bad thing.
and if you do have one of those agreements where they say, give me another 2 weeks, put it in writing.
It's, everything's in writing.
Yes.
Yeah. And you could have an appraisal contingency. Prices are crazy. Many buyers are overpaying over the asking price. And if you have an appraisal contingency, if that property doesn't appraise for what you're paying for or more, that gives you another out, again, tied into a date. There's title contingencies. That's where the attorneys come in. They do a bring down on the title. They make sure it's a clear title, no clouds. It can just close with no issue. If there's a dispute there, then of course the buyer will probably get out as well. Then a closing date. Closing dates are something that the buyer plugs in. No magic. You put in a closing date in the contract. And if it doesn't work for the seller, but they like everything else, they may say, hey, we love your offer, but can you close a week later? We have a wedding that day or whatever. Well, everything's negotiable. Once you make an offer, that offer gets presented to now the seller either accept it as it is, and now you have a signed agreement. There isn't any 3-day right of precision or anything in Connecticut. And if you get a signed agreement, that's great. But if you don't, seller may say, hey, I want, I'm on the closing. I don't want to leave my John Deere tractor. They may, then when they come back with that, now you're in the driver's seat to say yes or no.
One note before we go on. I know there's lots of questions coming in online and in person here. We're going to try and hold the questions to the end, but we will answer as many questions as we can.
I'm going to get into one more thing, the includes and exclusions in a contract. That is, if you walk into a house and you see all in there, in the listing, it says all new appliances, brand new kitchen, right? Walk in and you see all these beautiful appliances. They're not like built-in, they can come out, right? Some appliances can't, but you want to make sure that it lists those appliances as staying. Otherwise, they would be listed as not staying. Or let's say you see a beautiful chandelier in the dining room and it says chandelier doesn't convey. That chandelier will be gone. It will not go with the property. Or anything personal. Sometimes somebody has a comforter, all the curtains match. They want to take it all. Sometimes they leave everything. But there's usually an includes, excludes form that you can go through. And a buyer can actually say, I'm paying a good price. I'm a good buyer. I want that tractor, or I want the refrigerator because it matches. I'm never going to be able to match it. You can ask for things that aren't included. Maybe they'd include it. That's just one thing I wanted to mention on.
So bottom line of purchase agreement, there's a lot of details in here, and they can vary quite a bit. And while you don't necessarily have to understand everything, if you work with a licensed professional, that's what they're there for. But we're here to just help you, know the questions to ask at the very least.
Those contracts have hard dates and mortgage commitment. You have to know what those dates are because, and you just hope the salesperson is following those dates. Because if you go past that date or contingency date, your deposit is at risk. All the contracts will always tell you what the risk is if you fail to perform. And also for the seller, if the last minute the seller decides, no, I've changed my mind, I'm not selling, they could incur some fees or something. So that's really important to know those dates. If you're buying a property, go into your calendar, put all those dates on there and don't wait till the last day. Say, I need an extension, my lender needs more time, or whatever the situation is. Always get an extension for any date of contract. Wholesaling.
So one thing that's become pretty pervasive in the industry right now is known as wholesaling. It can be tricky. It is legal, but a lot of people, it feels to them like a scam because it can be something that you didn't know was coming. So this is something that you're going to see. Basically, what it is.
Can I read,
Well,
read the definition?
well, in a minute. Let's see how I do. All right. So basically, it's kind of like someone coming in and flipping your house before they even buy it. In the contract they're signing with you, if the wording is in there, you're basically giving them the right to resell your house before they even close on it. So they can re-advertise it, they can bring people in and show it. And so they may, so when you see these signs everywhere, buy houses for, we're buying for cash, that's generally what they're looking to do. They're coming in and they're not even giving you cash. They're going to give you the money that they get from the person they sell it to. So they're not putting anything on the line. They're just marking up your house. Again, perfectly legal, and it may even be something you want to do because it's, if you tell them, I want $400,000 for my house, and they say, okay, I'm giving you 400. They turn around and sell it for 600. Yeah, you could have gotten 200 more, but you got the 400 you're asking for. So is it necessarily bad? No. You just want to, again, know what you're getting into. Because you don't want to sell your house for much less than you could have. But there's lots of things, signals to look for in the contract. They're going to tell you. You're not going to see the word wholesaling. You might see assignment. You're giving them the right to assign their right to sell the house, or novation. These are some of the key words. But again, even if you don't know the words, just ask and work with again, if you've got a representative, ask them the questions. Are they trying to, wholesale my house here?
And with wholesaling, that wholesaler is never going to buy your house. They are not the buyer. They come on as the buyer and they're going to enter into a contract. It's typically below market value and it says a quick sale. But if you read the contract, it's all that fine print. It's going to say that they have, 75 days of due diligence. How is that closing in 30? It doesn't make sense. They're going to sell that contract to somebody else. That contract, somewhere in that contract, you're signing that you, as a seller, that you give authority for them to put it on the MLS. So let's say you have a house that's in disrepair and you don't want anybody in it and you're thinking, this is a gift. Oh, I'm selling my house to this guy. No one's coming in. Next thing you know, it's on the market with photos. And now you're going to take, a big hit. You're not going to get the market value. It's a quick turnaround. Typically, go ahead. No.
You're gonna get it at the end.
With somebody else comes in to buy it, but they have to market it, right? So an assignment, when somebody is assigning property, they say, okay, I have a contract, my contract, but in it, there's an assignment. Most real estate contracts today that, most professional they're using, they either say in there that a contract is or is not assignable. The assignment is clearly stated in a wholesale contract because the buyer on paper does not want to buy it. They're just tying it up for a period of time until they can sell it. And there's, it transfers the buyer's rights to a new buyer with the same contract. Okay? Novation is actually the buyer. Novation is a more formal process that replaces the original buyer in the contract to a new party. The difference from an assignment is where the original party remains liable. In a novation, the original contract is canceled and replaced with a new agreement. And the new party takes over all the rights and responsibilities.
So bottom line, just again, something to watch for if you're looking to sell your house, that you're not getting into wholesaling with it, at least without knowing what you're getting into. So some other key document issues, if you are gonna pull out of a contract because of one of those contingencies, and I'd like my deposit back, or the deposit's gonna be split between the buyer and the seller in this way. And that needs to be signed by both parties, the buyer and the seller, so that you're agreeing this is what's happening with the deposit. If both parties don't agree, that deposit stays in escrow until the parties come to an agreement or there's some type of judgment, in court that determines who's gonna get how much. But until that is released, until there's an agreement or, the judge releases it to somebody, technically that deposit is still in that house. So if that seller wants to relist that house, they have to be careful because technically there's still already a contract on the house. So they may need to put in any new contract, this is pending the release of the previous contract. So if you're buying a house, you want to be careful that there isn't already an existing contract. So ask if there are any existing issues around a deposit or a previous contract. Because you don't want to figure up a house and then find out someone else already has a contract on it because they can come back for that.
I was gonna say that, part of me and I, our job is we investigate complaints that come in against. And one of the things that would help people is a lot of people like to communicate in text or over the phone. You're in a transaction, you're in a legally binding contract. You should be communicating with your agent through email if possible, because it's all date time stamped. I sent over my termination. When can I expect it back? You want to have an email chain, even if you talk on the phone, follow up. As per our conversation 5 minutes ago, this is what we discussed. So you have something if you need it. Hopefully you don't need it, but it's good to have a trail of your communication.
Yeah, that's great. And any document you sign, whether it's the original representation agreement, the listing agreement, the disclosure,
Copies.
copies of everything.
You should get a copy when you sign, buyer or seller, all the time, always.
And a lot of things are digital these days, your representative may have an iPad or something like that, they say, okay, here, we'll sign the agreement here, and that's perfectly fine. But just make sure they email you a copy right then and there, and open your phone, make sure you've got the copy. Don't walk away from any interaction with anyone in this process without a digital or paper copy of something that.
But then if you signed it, you've already signed it. So a lot of times when I would meet with buyers, one of the first things I'd give them is a copy of a contract, one contract, so they can look it over and familiarize themselves with it. It's not a bad thing to ask your agent, hey, can you send me over the contract? I'll sign when I do find a house one day, because I just want to be comfortable and familiar and ready to, move forward when I find that special property.
Yeah, definitely know what you're signing before you sign
Before
it.
you sign it, because like I said, there's no, states have a they right of rescission, or people think because it's with some, product that they buy, they can get their money back. You can't with a house. You're locked in. Unless you find a way out to work.
So there are some extra little things you should know if you're buying into either a homeowners association or into a a condo association. They are governed by an elected board of unit owners in the association, of homeowners in the association. And those are the people who are going to set the rules for how you take care of your property, requirements, things you can and can't do. So you want to, find out who that board is and read the bylaws, read the budget, see if there are any assessments. If you buy in the middle assessment, you may owe money besides the monthly association fees. So you want to understand all of these things that come along with the property that you're buying.
You're gonna get a resale package. If you're buying a property in an HOA, you're gonna get a resale package. However, if there's less than 20 units, they're not required the information. You might have to go to the town hall and research it yourself. But when you sign a contract for, let's say, a condominium, there's gonna be a rider, condo rider. You look at the rider, it says, buyer has the right to review these documents for 5 days. If it's a resale, or I think it's 10 days or 2 weeks for new construction. So you want to look through, and in the resale package, it's going to include any special assessments on the property. They could have just had a special assessment and everyone's got to pay $5,000 towards a new roof. You're going to be on the hook for that if you don't settle that in the contract and say, maybe the seller should pay that, or figure out if they did pay that.
Yeah. And again, it's not bad getting into this, just know what you're getting into. It's all about being informed. It's nice sometimes to have other people worrying about and taking care of all the property issues for you. But you want to understand how that happened. And usually the board is going to hire a property manager to actually do a lot of the work for them, because they just own a house, a unit just like you, and they want to help make decisions, but they've got other, lives, and they don't want to be collecting, association fees and hiring contractors to work. So they're going to hire a professional, and that professional has to hold a community association manager registration, which is managed by our agency, so real estate salespeople, real estate brokers, and community association managers are all credentialed by Consumer Protection. So the board has to hire a registered professional manager. So you may even want to check with that, who is the property manager for this association or this condo association? And, check on them. Because again, these elected board members don't always know the law. They're not trying to skirt any laws. They just may not know that they need a registered association manager. And do your homework. Now, if you do buy into an association and you have a problem with the board, you have disagreements, the agency or the body that can help resolve those issues is the courts. Because you're in a contract with that association, and the courts deal with contract issues. So we don't regulate the boards. We only regulate the manager. We only regulate, if the manager is violating the license. Just like with most of the licenses we have, we don't regulate the quality of their work, only the fact that they're following the laws. But if you find that your property manager, you believe they're violating law, that is something we can assist with. But if you have a problem with policies or the way the board is operating, that's something you would have to take to court. Again, just know that. Now, that said, we do have our complaint process for any of the credential holders that we regulate when you're working with them, whether if it's a salesperson, a broker, or a property manager. You can go to our website, right on the front page there. I don't think that's going to appear unless we switch over and share the screen. But right on our homepage, you'll see up top, file a complaint. And it's going to tell you here, things you could do to kind of help yourself, the types of complaints we handle. But certainly one of those is real estate. And as you follow through and follow the links, it will tell you, okay, if you're ready to file a complaint, go here. And it'll bring you back to that same e-license website that Kylie showed you earlier, where you look up a license. That's also where you file a complaint. And that comes to us. And the way the complaint process works in general, we are here to protect the consumer by ensuring that the people we license are following the laws and following the rules. We unfortunately are not lawyers for the individuals doing the process. We're not representing either party. We're generally trying to mediate issues and ensure that the licensed individuals are following the licensing laws. So if you feel you're harmed, again, contact us so we can determine if they broke the law, but you may also need to go to court to get any restitution if that's something you're seeking.
I just want to add in regards to the filing a complaint. You file a complaint, it does become public knowledge, but not during the investigation. Once the investigation is done, then you can do an FOI. The information in regards to the,
So FOI, I mean Freedom of Information Act, so it can request information on any closed case. And like you said, yeah, any information you provide us does become available under Freedom of Information. There is the option when you're filing a complaint online to file anonymously, which you're welcome to do, but obviously that has limitations. We don't know who you are. We can't follow up with questions. We can't provide you, provide you any updates on your case. But that is an option if it's the right situation and you want to remain. But that can only pretty much be done online. So you're not logging in, you're not providing your name. Other ways usually have, if you send us an email, obviously your email address or the email address that is coming from is connected to that. So now we'd like to certainly open it up with questions. We'll start with questions for the people here in person. And then Kyle, who's assisting us back, will review the questions online. And I'm sure there's lots. We may not get to all of them, but we will get to as many as we can. But in person, who has the first question for us?
Well, what, I have a question. When you mention contingencies, like, while all the contingencies are negotiable, I believe the inspection is stated like in mandatory, like 14 days by the state. So it's, that's what I know. You have to complete inspection within 14 days of acceptance of order.
15 days isn't a hard number. That's not a number that the state has out there. That is a negotiable number.
This,
Yes. The thing is, in a busy market,
Okay.
it could be hard to get an inspector 2 days or 3 days. So, and then you have to have time for them to write up a report and get it to you, and then you review it. And all that has to happen within that contingency period.
for some reason, in many contracts that I've seen, like as a realtor, I've seen that that's kind of like stated, like mostly
Yeah,
accepted.
It may be in the standard version of a contract you use, 14 days may be, typed right in there, but that's not a law. So that can be
Okay,
negotiated.
It's not a mandatory kind of like, okay.
Great question. Thank you for asking.
Repeat the question. We didn't hear the.
Okay, thank you. So the question was, for inspections, whether there is a defined legal limit on how long you have to allow for an inspection to be completed. And he thought maybe there was a legal requirement that has to be done in 14 days, but there is no official number of days. It's between the seller and the buyer to come to agreement how long they're going to give for that inspection to be not only completed, but decide whether or not you're going to pull out of the contract because of it. So you want to leave yourself, as Joe was saying, time to schedule it, get it done, let them write the report, let you review the report.
It's not 10 days.
No, but 10 days is not defined anywhere. It's totally just.
No number defining the number of days. Thing is, a lot of people make it an offer and you want to go quickly because the seller is waiting on this. They don't want to wait 3 weeks and then you pull out. They're like, oh, we just lost 3 weeks. You want to keep it as tight as possible. But if you schedule your home inspector, you only have 2 days and then you may want to get an extension rate So we can,
But on the same token, deposit should be deposited within 3 business days, so that's,
the deposit is collected at the time the offer is made. The broker who collects the deposit has 3 days to deposit that. There's no 3 days to collect it. It's new and the contract is written.
right.
Yes.
Like a deposit, it is a 3-day, but it could be like negotiable too, right?
No,
It cannot be,
no.
it cannot be extended.
The initial deposit is not negotiable. There's always there could be a second deposit. And then the buyer would put when that deposit would be handed over.
So the broker only has 3 days to deposit the money.
I've done deals where I was asked to, and I kind of like amended the time, like I was given like more time than 3, because like it's 3 days, not business days, it's a 3 calendar day.
3 calendar days,
Yes.
correct? Yep.
And some people like asking for more, and I've amended the contract by offering like 3 business days, including kind of like assuming like the holidays too. But I cannot do that.
Oh, our statute states 3 days.
3 days.
So
And that could be a condition for termination.
we got fined.
No, I'm saying like if the person,
If they didn't have a
Yeah.
deposit.
Right.
Can
the seller might terminate the contract because of not.
be default of the contract and the seller could give notice that the deposit wasn't received. It's all in the contract.
Well,
I mean, it's written in there that what the seller would do if the
I mean, I was told by my broker that I could amend and kind of like extend the time, assuming, I mean, like, especially during the holidays. I mean, some people asking for more time, like to provide the check out of state kind of mailing.
I know part of the way of doing it today is where the buyer takes a picture of their check and sends it over. That's not collecting the deposit.
Right.
Collecting the deposit is having the deposit.
Now it's more kind of like direct link where people can do like transfer, but not every broker accept transfer.
Just pick up a check.
Yeah, so, and so just to kind of
State buyer, then it's.
summarize what we're discussing, in case you can't hear both sides of the conversation. Once the deposit is made, the deposit goes with the purchase contract. So if you're free to buy a house, you sign a contract, you give the deposit. The broker, the seller's broker needs to deposit that check within 3 calendar days. And that's a protection for both parties. Because if it's not in that escrow account, that check could disappear, or you don't know what. So one party, you don't have that protection of the deposit if it's not in that escrow. And again, there is a legal requirement that once that check is submitted, they have 3 days to put it in that escrow.
I have a question. Is there a limit time for people to complain in terms of a deal that went bad or whatever?
There is no statute of limitations as far as making a complaint. Certainly the sooner the better.
Courts have. Courts have.
Yeah, I mean, certainly if you're gonna file a suit, there may be
I think it's 5 years.
5 years on filing a court.
To get their,
Depends on it depends on the transaction. So if you're thinking of filing a suit, you can contact a private attorney. It'll depend. You may have different costs of action, contractual or otherwise, so. Can't really comment on.
Yeah, well, certainly when you get to that point, having an attorney is key.
When you write the contract, right? So many sellers don't like it. You put like a subject to the appraisal, right? But that one is important because sometimes the price is really high, but the price coming so low. If that one, if you don't put in the contract, if the buyer want to back up, it's protect because the price will come a little down for the listing price or no?
So the question is about the appraisal contingency.
Yes.
So in the contract, you put a contingency that if it doesn't, appraiser doesn't appraise the house or enough to be able to get a loan, then you get out.
Well, the thing is, if the lender is gonna reject the application and you're not gonna get approved, that's your financial out. That's your financial contingency. You got rejected for the loan. Okay?
No.
Yeah, so you want to make,
No, it's I am approved for GYC, all right, but at the listing price is more higher than the appraisal coming in. right? If my buyer don't want to pay more than the houses or like I offer, right? If I don't put something in the contract, like a subject to appraisal, right? I can back up to the deal or no?
Are you paying, is the buyer paying over the asking price?
Yes,
Okay, and they want to have the appraisal writer in there?
yes,
Okay, so if they have the appraisal writer, if the writer states property has to come in at the value you're purchasing or higher.
okay,
If it doesn't, then the buyer would get their deposit and move on, as long as they're within that contingency timeline.
okay, okay.
But yeah, nothing is automatic. You want to make sure that it is a contingency in the contract. So yeah, so you want to state in there.
Put everything in the contract.
Okay.
Another question. If you're saying that the realtor or like the salesperson does not control if the seller provide the disclosure. And you're saying like the realtor would not be responsible for the seller to provide the disclosure. Are we gonna, like, as a realtor, like, are we gonna be fined by not providing the disclosure by MLS? Because it's an MLS rule, like,
Well, it's not an MLS rule.
it's not?
It's not, no.
Okay.
I mean,
It's not an MLS. Well, if the seller, if the agent provides the seller a disclosure, fill out, the seller doesn't fill it out or doesn't get it back, the agent should ask for it again. If they don't get it back, then they would tell the buyers they don't have one. Seller's not coming, and then they would get a $500 credit at closing.
But the buyer shouldn't let it go. If the buyer doesn't get one, the buyer should be persistent about getting it. And I advise if you don't get it, walk away from that house because you don't have the information you need to make a smart purchase.
Well, there's a lot of houses that are for sale as is, right? So you're looking at it and a buyer can still have a home inspection for their own peace of mind to know what they're buying. But it may not be, seller may not be willing to fix or repair anything. So the as is really what it is. And they may not want to, a lot of sellers don't want to include it, especially like with these wholesales, right? They don't want to include it. They're just going to pay the $500. They come to that in their head that it's going to cost us $500. We're not going to provide it. It's, go ahead.
Probate.
Pardon me, probate?
They don't have.
No, you don't have to. We went through a list of, and that's, you know, if you ever need that, you can just reach out to one of us. Probate does not, conservators, trusts, like I said.
So yeah, it's just knowing what you're getting
Yeah.
into.
Yeah.
So Kyle, do you have questions for us from online?
Yes, we have a few online. One is, will the buyer's representative do research on the property, check on open permits? What about my attorney?
Okay, so the attorney generally doesn't check for open permits. Who will check for the open permits? It would either be the buyer. I would encourage the buyer to ask their representative, whoever is selling them their property, please go to the town hall and look, see. I mean, you can go to the town hall with your phone and just snap pictures of everything in the file. Very easy. But that's it. They should look to see what's going on with the property, any property.
Costs money to get the copies, right?
Copyright.
Town hall.
Town hall could charge you for printed copies,
You could
but
just
yeah.
snap it with your phone too and go to the office and print it just as easily.
What's next?
Next question is, if solar panels were not paid off fully by the previous owners, are the costs of the panels then passed on to the new one?
It depends on the solar agreement. So there is no definite situation. Again, if there's solar panels, you're gonna wanna look into that pretty significantly. You're gonna wanna read the contract. And sometimes the sellers don't even realize. Sometimes they sell a house and then they keep getting bills for the panels and they didn't realize that even though they sold the house, the loan for the panels is still with them. So you want to be just as careful as a seller if you've got solar to understand how you're transitioning your responsibilities and ownership to the buyer.
It should be assumed by the buyer. And when you look at a house and you see solar, I mean, you can't miss solar. There's no way you can miss solar. When you see solar, you got to do something about it. And if you're the buyer, you want to know what's in that contract because You shouldn't be assuming that. Otherwise, that seller's on the hook and it's, you know, you have complaints like that. That is not something you want to get involved with. It's not fun.
And it's tricky because there are usually multiple companies involved. There's usually one company that sells and installs the solar panel, but then there's a separate company that is actually handling the loan for the panel. So there's a lot of parties involved. So it's very complicated.
So in the property disclosure, that would be listed somewhere.
There's actually not a specific line at the current time. It's something that we're looking at in the future to be included in the disclosure report, but there's nothing right now that specifically discusses solar. So that's what I was saying. If you see solar, do some extra homework.
Did say something.
Yes. What's next, Kyle?
Next question is, where can buyers access a purchase agreement draft so they can review it prior to an offer to become more commercial?
Great question. So every brokerage uses a different contract, either with their own or they're a part of different associations that they're going to use that standard contract. So you want to ask them, and as Jill mentioned, you don't have to wait to make an offer, say, hey, you know, when you're making that agreement, that representation agreement or that listing agreement, you know, say, hey, can you give me a copy of the contract that you would use if I were to make an offer on this house? That way I can start reading it and understanding it before I get to that point.
Next question, not sure if there's more context, but what about vacant land with no structure? That was the only.
So if you're buying vacant land, I mean, there's a little less to it. You may not do an inspection, but maybe you will. There may be some
You're gonna.
perk testing.
You're gonna do an inspection. You may go to the town building department, see if there was a perk test, see if there's any contamination, see if it's buildable. You want to build a house and now you just bought wetlands. Oh, you can't build. So, you know, have an attorney look into that for you. You know, the agent's gonna give you whatever they got from the seller. So you just go to the town hall, give yourself you're not gonna have a home inspection, but say, I want 2 weeks for due diligence to see if I can do what I want to do with this property. I don't want to buy this property, but I can't do what I want to do with it. So you got to give yourself some time.
And there's one other thing I want to mention, that is a scam that's growing out there. You probably read about a big case that happened in Fairfield last year, where, you know, people, especially outside of the country, are trying to sell property that they don't even own. And because a lot of this is happening, a lot of these deals happen online, sometimes it's difficult for the listing agent to verify that the person selling the property is who they are. So we've had people buy property from who they think is the seller, but then the real owner shows up and says, I didn't sell this property. And then you're in a tough spot. So it's just another thing you can ask for as a buyer to work, you know, talk to your agent, have them talk to the listing agent to really make sure that there's been some legwork to verify that the person who's selling this house or this property, usually it's vacant land more than within a house. Usually it's vacant land, but say, you know, how have we verified that this seller actually owns the property?
A lot of times it's an absentee owner. The owner doesn't live in the area where the land is located.
Right.
All this information is online now. Look at an aerial. I give ideas, but
Yes. I think they know all the tricks, unfortunately. But okay, next question.
Question is, clarify or specify the statute that was stated regarding the 3-day provision in real estate contract.
So the 3-day that Jill mentioned is there's 3 days to deposit the check into the escrow, the deposit check. There is no 3-day.
right of rescission.
Yeah, there's no 3 days to change your mind. Just like a car mechanic, there is no 3 days to change your mind. Right now, the only law that I'm aware of, you know, that's a 3 days to change your mind is signing a contract with a home improvement contractor. But as far as buying a house or buying a car, there is no 3 days to change your mind. If you sign a contract, you're in that contract. So again, know what you're signing before you sign it.
The last question, kind of a softball, can we send the slides to attendees online?
Absolutely. So we'll review this recording, make sure that It looks and sounds okay, and we'll share this online. We will also post the slides. I know there's not a lot of information on the slides themselves. They're mostly talking points. But we're happy to put both of that up there, and it'll be on the webpage where people, learned about this and signed up for this website.
All the online questions.
Excellent, great questions, thank you. Any more in person?
So you talked a little bit about how buyers and sellers don't necessarily have to be represented by a realtor or a salesperson or whatnot, but I don't know if you talked about attorneys and that side of it, and, are they required to work with an attorney? And if so, why is that?
Required to work with an attorney and for the closing.
For the closing.
For the closing, yes, they have an attorney.
Yeah, so I'm just saying, like, is it a requirement by the state that because I've had that question or as a realtor, where a first time home buyer might say, are you required to work with an attorney?
Well, the question is, so we talked about whether you're not required to work with a salesperson or a broker during the process, but it's beneficial because they know what they're doing. The question is, are you required to have an attorney as part of the closing process? And I'm actually,
Well, part of it is gonna be, if they're getting a mortgage on that property, there's gonna be an attorney involved. Because they're gonna be seeing the paper signed by the lender. I believe there is something that says you do need an attorney. I don't know. Not that easy to find.
The short answer is, yeah, do we require lawyers? I'm an attorney, right? This is my job. You're opening yourself up to a lot of liability if you try to do a closing without an attorney. Attorneys are expensive, they're annoying, right? They're a necessary evil. We mentioned a lot of these things about title queries. Is there open title? Is there as is condition? Is it mandated by law? Unclear. Is it a really good idea to have one? Because if you don't have one and anything goes wrong, you've got no recourse. Other than hiring an attorney and going to court, at which point you're in an even deeper mud than you were before. So I personally, speaking as Annalisa and not speaking as anything for DCP, I would never do a real estate transaction without an attorney. And I would hire an attorney separately because that particular transaction law is not my field. I would want somebody who knows what they're doing. So if anything goes wrong, I've got recourse.
How do you get title insurance? If you don't- Isn't the attorney the one that writes the title?
So again, now you're getting to a field that I don't know as much about.
I do know a little bit about.
All I do real estate.
When you
So
go to the closing, the attorney is the one that says,
Title
you're
insurance.
required to buy this title insurance for the lender. Now, do you want it personally? Do you want to protect your equity as it builds? So that's done through an attorney.
And I'm a realtor and I would absolutely recommend that, but I just wanted, that might be a question that home buyers and
So-
sellers have, and it has come up.
If it comes up with people that just, I don't want to spend $500. I know what I'm selling.
Right.
Well, you know what? I would do the disclosure statement.
Mortgage or the financial company is gonna require.
The financial, if there's a mortgage, you're always gonna have it, but that attorney's gonna be working for the bank. You're paying for the bank's attorney. And they might help you a little bit here. But you could also have your own attorney on top of that. Sometimes there's
You can use the same one.
people.
No,
it's similar going back to dual agency. Understand where, whatever profession you're working with, understand where their duties and loyalties
You
lie.
got 5,000 closings over here, or just you buyer over here. So what we gotta represent.
Great questions. And yeah,
Wholesale, will they required to be licensed?
so, yeah, so if someone is buying your house through that wholesale process, they do not need to be a licensed real estate person, but many of them are. And if you're dealing with anyone who is a licensed professional, broker or salesperson, if they're wholesaling, if they're the seller of the house or if they're the buyer of the house, they have to tell you they're a licensed professional, even if they're not acting in that role. Even if they're just the owner of the house and they just want to sell their house, they have to come out and tell you, they have to disclose that they're a licensed professional. That you understand, they may have a leg up on you on knowledge and experience, so that you can make sure that you've got your own experienced person help.
It's not,
That reminds me of something else in a real estate contract. either agent, the listing or the selling agent has a relationship or is related, best friend, mother, brother, sister, aunt, to one of the parties, either the buyer or the seller, they have to disclose that in the contract, in writing. In writing, contract. Big.
But as like wholesalers, you mentioned that they might list your property on MLS. That's not licensed. Can they have access to
So we'll
MLS?
hire somebody to do it. They'll give it to their friend. They're not.
So like I've seen the other cases, like when FISBA, like when the people wanted to sell by themselves, they use some online services where they pay a fixed fee, and that person lists the property on MLS while not really like representing the buyer or like representing the seller.
That's an unrepresented seller because it's what they call an entry-only listing. I want to list my house, I'm going to pay you a flat fee, usually, $500 to $1,000, and they put it in the MLS. And the MLS, right there, it says agent to agent remarks, call Mr. Smith for all showings.
So that's acceptable.
So you're calling the owner. Well, it's acceptable if you're a salesperson and your broker allows it. If your broker allows it. The broker doesn't allow it, not acceptable.
Okay, but it's not.
That's called,
It's not.
It is legal.
that's called
It is
limit,
legal.
it's legal, it's called limited service listing, a limited service. You can say, I want this, I want that, I don't want it here, I don't want it.
And just for reference, for anyone who might not know, so MLS that we're talking about is the multiple listing service. That's basically the internet service that gets your house listing available to all of the, the real estate professionals out there and to the public so everyone knows. So, but the general person can't, an unlicensed person can't put their house on MLS. So you need to work through a licensed professional, either as your direct representative or like I said, a limited service just to put it out there for you.
That's-
But we don't, as an agency, regulate MLS. We have no oversight. There are policies and procedures.
Or the Association of Realtors.
Or the association. Excellent. Well, thank you so much, everyone. We hope this was beneficial and best of luck in selling and or buying homes in the future. And if you do have questions, don't hesitate to reach out to us.
Just a note, if anyone's looking to get their parking validated, Kyle will be right back to do that for you guys. Hold on a second.
Yeah.